Good afternoon, everybody. Welcome to our Chancellor's Forum. This is our, I think, third forum we've had this year, and it's great to see such attendance. We have a few more coming up. We have a Commonwealth Court candidates on May 3rd, and we have the 6 deans of the area law schools, which are all new within the past 2 years, on April 25th. I want to thank Pennsylvanians for Modern Courts for partnering with the Bar Association to put on this forum. Few housekeeping matters. We are live. PCN is live streaming this from their app and website now. Tomorrow it will be shown at 10:30 p.m. on PCN. The hashtag is #Decision2015 if you want to tweet. And I just want to thank everybody, and I'm going to hand this over to President Judge Gantman, who I thank very much for coming and giving us a welcome for the new candidates and for all of you.
Thank you, Chancellor Gross. I am Susan Pikus Gantman, President of the Superior Court of Pennsylvania. It is indeed a privilege to address you today, and I want to thank the Philadelphia Bar Association, Chancellor Gross, Chancellor-elect Mary Platt, all of the staff of the Bar Association. I also want to thank my friend Tom Burke for moderating today. We appreciate it. And before I start my brief remarks, I just would like to introduce our judges and our staff who are present. Judge Ann Lazarus, Judge Jeff Moulton, Mike DePasquale, our Executive Administrator, Peter Johnson, Legal Systems, and Phil Yoon, Chief of Central Legal Staff. Also, Maida Malone is here, President and CEO of Pennsylvania for Modern Courts, and thank you for partnering with the Bar Association. We are fortunate to have outstanding candidates for the Superior Court. So I want to welcome all of you and wish you good luck in the primary and then in the general. I look forward to working with you January 2018. The first level of appeal is taken to one of Pennsylvania's 2 intermediate appellate courts, either the Superior Court or the Commonwealth Court. These courts determine if errors were made at the trial court level. These courts have statewide jurisdiction, meaning that the judges of these courts have authority to hear cases from all over the state. The Superior Court was established in 1895. The court has 15 commission judges and 6 senior judges to handle its docket. The Superior Court is the busiest intermediate appellate court in the country, handling approximately 8,000 cases each year. A panel of 3 judges is neutrally selected to ensure impartiality in the final decision. The Commonwealth Court exclusively hears administrative law and government-related appeals. The Superior Court handles the appeals from most criminal cases, family law matters, contract cases, products liability cases, other commercial disputes, and restrictive employments, tort cases, medical malpractice, insurance fraud, in other words, everything else. The quality of review in each appeal is critical to the justice system and to the litigants in each case. We want to thank PCN for televising this forum. PCN is widely recognized as the nation's preeminent state public affairs network, so thank you. It is my pleasure to introduce President and CEO of Pennsylvania for Modern Courts, Maida Malone.
Good afternoon, everyone. It is truly an honor for me to be here with my distinguished colleagues and judges, especially President Judge Gantman and Chancellor Gross. Thank you all for joining us. As many of you know, Pennsylvanians for Modern Courts aspires to create conditions for a statewide judicial system in which all Pennsylvanians come to our courts at any level, whether as litigants, witnesses, jurors, or lawyers, with knowledge of the judicial system and their roles in it, and the confidence that they will be treated fairly, impartially, and with respect. And while we, of course, remain committed to merit selection of our judges and justices, while elections are still the means by which we choose the ever-important judicial roles in our Commonwealth, we must do everything we can to ensure that the electorate are as well informed as possible about the candidates and the impacts of their decisions in all of our lives. And it is in that spirit that we are so pleased to be sponsoring this event with the Bar Association, our great partner. So thank you all. And now it is my great pleasure to introduce our moderator, Tom Duffy.
Hello, everyone. We, in addition to the judges that have put out, we have Judge Messiah Jackson here, and I saw Judge Brad Moss here. Can everyone hear me? Is that better now? All right. And I'm honored to be able to do this and be your moderator today. We are going to give out cards, or they should already be at your place if someone has a question. One of the main problems that we're going to have here today is going to be time, because we have so many candidates. The format that we're going to proceed today will be each candidate will be given a moment to introduce themselves, and then after they introduce themselves, we're going to start with the questions, which no one has seen but me. So you know, though, we did send topics out to the candidates so that nobody got sandbagged about, oh, we never thought this was going to be asked or that was going to be asked. And none of them are going to be asked to produce, for us purposes today, their tax returns in conformity with the way that our President of the United States is proceeding. So we're going to be okay in that regard. One of the things that I decided, or with Debbie, wasn't in charge here, is that, you know, the first shall be last and the last shall be first. So rather than somebody always leading off and somebody else always going last, we decided we would go by alphabetical order, but then after we started with Bill Kay, he would then become last, and we would move so that the person who, and if we get through 9 questions, everyone will have the first question and the first answer and the last answer. So what we'll do, if we can, is start off with a brief introduction where each candidate, and we'll start with you, Bill, to get up, and our format is going to be 1.5 minutes for answers, but only 1 minute for this first introduction. So if you want to get up and give us 1 minute of why, introduce yourself and why you're here, that would be great.
Thank you.
Thank you.
I want to thank the Modern Courts of Pennsylvania.
You got to probably sit down.
I want to thank the Pennsylvania Modern Courts and the Philadelphia Bar Association for having this.
It's not on.
Are we good now? Yeah. We're better than good. All right, thank you. Good afternoon. My name is Bill Kye. I want to thank the Pennsylvania Modern Courts and the Philadelphia Bar Association for having this forum. I'm a family man. I'm running for the Superior Court to keep our families safe. A statewide practitioner, focusing primarily now in the criminal defense world and juvenile defense world. Previously, I had been a prosecutor with our Office of Attorney General, covering the western part of the state. Distinguished career there, worked for some outstanding individuals, proud of the work that I did in the Child Predator Unit, where I protected our children. I also segued into environmental crimes and elder abuse. I'm very proud of the work that the agents did there as a part of a team to protect our citizens. Again, I'm focusing on a new direction for our courts, one that promotes diversity, one that respects accountability, and one that gets input from the people. Again, thank you for having me. I look forward to the discussion and the questions. Thank you.
Mr. Duffy, I'll just say seated. Is that okay?
Yeah, whatever.
All right. My name is Emil Giordano. I'm a trial judge in Northampton County. I've been a judge for 14 years. In our county, in a small county like Northampton, we had the honor and privilege of trying everything from death penalty cases to medical malpractices to adoptions, sometimes in the same day. I've had the opportunity to be an assistant DA, assistant public defender, private criminal defense lawyer. I was a civil trial lawyer. I've had over 100 jury trials in my career, and several hundred non-juries. And I would suggest to you that my credentials and my background make me uniquely qualified to sit on a Superior Court. And I'm happy to announce I was, as well as numerous candidates sitting up here, I was highly recommended by the Pennsylvania Bar Association to sit on a Superior Court. Thank you, sir.
Thank you. I want to thank the Philadelphia Bar Association, the Pennsylvanians for Modern Court for sponsoring this event, and also Attorney Duffy for being the moderator. As many of you know, of course, this year in Pennsylvania, we're going to elect 7 statewide appellate judges. With only 31 elected statewide appellate positions, we're going to be electing almost a quarter of the Pennsylvania judiciary. This is going to have an impact on our courts for generations to come. I'm running because I believe that we need individuals who can address the complex and difficult legal issues facing our Commonwealth. I believe that we need people who have well-rounded judicial and legal backgrounds. I'm a judge of the Court of Common Pleas of Blair County, where I handle a little bit of everything. I also have a private practice background as well, and have been a former prosecutor. So for me also, it's about public service. And I have served in many capacities in public service in my career, and I'm looking forward to hopefully having the vote of the people in the Commonwealth. Thank you.
Hi, I'm Judge Debbie Kunselman. I come here from Beaver County, and I'm proud to tell you that I'm the first and only woman ever elected to the Court of Common Pleas in my county. And I have served on the Court of Common Pleas in Beaver County now for 12 years. This is my 12th year. And prior to taking the bench, I also had a private practice for 13 years where I did personal injury work, employment discrimination, and family law. On the bench, I have handled civil cases. I'm the civil administrative judge in Beaver County. I've also handled juvenile delinquency and juvenile dependency cases, and all family law cases, so child support, divorce, custody, PFA, all of the like. I'm also proud to have received a recommendation of highly recommended by the Pennsylvania Bar Association. I'm very excited about the opportunity to perhaps serve on the Superior Court, because one of my favorite things about being a trial judge is doing the research and writing opinions, and I look forward to hopefully getting to do that on a full-time basis.
And my name is Judge Maria McLaughlin, and I am a judge right here in Philadelphia in the Court of Common Pleas. And why I believe my background uniquely qualifies me for the Superior Court is this. I started off as a young intern for the State Senate, working for the legal staff, learning just how a bill is written. From there, I went to clerk for the President Judge of the Superior Court, so I have the background as a clerk. Then, after that, I went on to the Philadelphia District Attorney's Office. I was an assistant DA and a chief, one of the youngest female chiefs appointed under Lynn Abraham. In that capacity, I argued numerous cases before the Superior Court, and now as a judge in the Court of Common Pleas, in the largest judicial district, I have ruled thousands of times. I've had only 5 appeals. I sit between family and criminal, and I've never once had a decision overturned.
Thank you very much. My name is Jeff Molden. I was honored this past summer to be appointed to the Pennsylvania Superior Court after being nominated by Governor Wolf and unanimously confirmed by the Pennsylvania Senate. I've been on the court for about 7 months now, and while we are an under-the-radar court, I have firsthand experience now knowing just how important the work is of our court. I believe my professional strengths line up very well with the attributes of an effective appellate court judge. I have a broad range of experience. Both as a federal prosecutor, I was a law professor, counsel to both the governor and United States senator. In terms of integrity, I believe, earned my reputation for the highest integrity, and I think that's important given the trauma that our judicial system has been in the last few years. It's important to have folks with unquestioned integrity on the court. Finally, my approach to both life and to judging fits well within the norms of judicial temperament. I bring an open mind to every case. I decide cases based on the facts and the law without any agenda to bring to the table. So in short, I'm the sort of judge I think that any litigant or a lawyer should be happy to appear before, whichever side of the V they happen to be on. Thank you very much.
Good afternoon. My name is Judge Carolyn Nichols. I also am a Common Pleas Court judge in Philadelphia County. Thank you so much for having me here. I've been a judge since 2011, serving in the criminal court division. Most of the cases that I handle deal with family violence, domestic abuse, child abuse, sex crimes. So I conduct a lot of jury trials, between 30 and 40 jury trials a year, over 100 in the last 3 years. So I'm very familiar with the jury process and how powerful the jury process is. I always tell my jurors that by coming into the court, you transform the Constitution from a piece of paper into a living, breathing document. You make the Constitution live because you ensure that we're going to have a fair and impartial jury trial. So like, oh, this isn't something to get out of. So they kind of light up. Before I became a judge, I was a lawyer for 20 years, practicing civil cases, civil rights cases. One of the last cases I handled before I did become a judge, a case involving African American and Latino kids that were prevented access from a pool, some about justice, and that's what I want to do for the Superior Court. Thank you.
Good afternoon, and thank you for having me here at the forum. My name is Paula Patrick. I'm a judge here in the City and County of Philadelphia. I'm uniquely qualified for the Superior Court, and that out of law school, I built a practice from the ground up. Originally, I'm from North Carolina. I came here out of law school, and I built a pretty successful practice, general litigation practice, for almost 10 years. I ran for judge in 2003. I've been on the bench ever since then. Unlike most people up here, I've sat in every major division of the Philadelphia County Court system. Of course, listening to thousands of cases. I started out in juvenile division, the family court division, the criminal trial division. Of course, I did a stint in custody as well. And of course, currently I am in the civil trial division. One of the things that I can say mostly about myself is that having been a trial lawyer, I learned the nuts and bolts of the practice. So I understand where practitioners, what they deal with. I also understand what trial judges do. And I've written over 400 opinions to the 3 state appellate courts in my tenure of being on the bench. And I'm running because I do believe that our Constitution should be preserved. I do believe that with my background and experience, I am uniquely qualified to render justice to all the citizens of Pennsylvania.
Good afternoon. My name is Craig Stedman. I'm the District Attorney in Lancaster County. I've been a DA since 2008. Prior to that, I started out as an assistant DA, did that for about 17, 18 years, both appellate practice and trial practice, prosecuted retail theft of a hamburger to the death penalty cases, just all the gamut of what I've seen. I also was a special assistant United States attorney here in Philadelphia a few years ago. I've got roots across Pennsylvania. I was born in Lawrence County, raised in Bucks County. Of course, I practice in central Pennsylvania. I'm a veteran, United States Army. I joined because my father and my grandfathers had joined, but also I truly believe in the principles of our country. And at the core of that is that we need fair and equal justice for everybody. And where there's law, there is freedom, and I actually believe in that. I've dedicated my career to public service, and I want to bring my experience and my values to Superior Court. I also am honored and humbled to get the highest recommendation from the Pennsylvania Bar Association, and thank you for having me.
Okay, thank you, everyone. So we'll start with the first question. I consider this the Judge Gantman question. Considering the limited number of cases heard on appeal by our Supreme Court, the Superior Court is often the last stop for parties. The volume of cases before the Superior Court is in some ways staggering or overwhelming. What personal policies or procedures would you and your staff put in place if you were elected to make sure that everyone got a full and complete hearing in the cases that were decided by you? And you're first, Mr. Kay.
Thank you. That's a good question. I've always worked very hard. I've always had demanding and excessive caseloads in my own private sector practice as well as the public sector practice. I think the staff would want to do well to be quick but not hurry in these decisions. I think the types of screening or rules changes that we would need would be to have some vetting of which types of cases would require just submission and decisions on the briefs versus the oral arguments. I also feel that we have to be mindful and respectful, though, of the litigants. I think in particular, like when you have businesses or small businesses, those particular types of clients should participate in a specialty type of a court that I would embrace with the rules in terms of a commerce type of a court. So I think those very specific, palpable changes, just minor tweaks, and a lot of hard work, rolling your sleeves up and doing the day-to-day due diligence, I think would do well for our citizens here in the Commonwealth.
I wouldn't really stop doing what I'm doing now. I know the Superior Court is probably the busiest appellate court in the entire nation. I would hire very good law clerks, and I would delegate work accordingly. I would overview all the cases that come through, but I don't think it's possible for a Superior Court judge to read every transcript that comes in of every case. So you have to have good people in place, number one. Number two, you have to have good common sense and a good feel for the law. As a trial judge the last 13 years and being in private practice and a DA and a defense lawyer, I am familiar with every type of case that would come before the Superior Court, both as a lawyer and as a judge. And you just have to stay on top of your staff and make sure things are done in a timely fashion.
That's a good question. I think that it really comes down to hard work and teamwork. Okay, you sit with the other judges on your panel, and you have to work hard. I have a strong work ethic. All the lawyers that would practice before me would tell you that. I get my decisions out now in a timely fashion, even though they're well-reasoned decisions, and I think that's really the key. Prior to being in the Court of Common Pleas right now, I do a little bit of everything. So I write decisions on all different areas of the law. Prior to being a judge, I was a prosecutor for 15 years. I served half of that career as the equivalent of the first assistant. So I helped manage the office, run the office, supervise other lawyers, try major cases. But I was also permitted to have my own practice, which I operated on a regular basis, doing litigation, family, civil, labor law litigation. And I also was also a professor at the same time. So I have a strong work ethic, and I think that's necessary to the Superior Court to have people who work hard, have well-rounded experience, and are team players. I believe in working as part of a team. I think that's important. I probably learned that being an infantryman in the United States Army Reserves and over the course of my career in public service. Thank you.
I think the key to handling a very heavy caseload is prioritization. One of the things I do now during argument court that we have in our county is I go through the cases beforehand and I sort of rank them in terms of their complexity. And then when it's time to argue, I take the most simple cases first so that those people can state their argument. They don't all need 15 minutes per side. So they may only need 5 minutes per side. And we go through each of the simpler cases first, and I end with the most complex case of the day so that I can give those parties extra time, because I oftentimes need extra time to sort through the complex issues that may be before me. And that way, if they go over 15 minutes, nobody's anxious, nobody's worried. It's just the lawyers left in the courtroom who are on that particular case. I think the lawyers appreciate that in terms of the argument structure because they're not sitting around through something that's really, really complicated. If they have just a simple issue, they come in, they make their case, and then they go. And then we do the same thing with working on the opinions. I delegate things to my law clerk. We set deadlines, and we try to get everything done before the next round of arguments comes in so that we can keep things moving in an orderly fashion. So that's how I would handle my workload.
And so again, this is where I believe my background comes in. Sitting in Philadelphia with the caseload that we have, the transition to the Superior Court would be a smooth transition. Additionally, for most of my life, I was a single mom. That also makes it a lot easier when you're used to juggling everything in your household along with your workload. It comes easier. So it's something that is easy for me to do, is to juggle. But the most important thing, and what I never forget, is that it is my name on that order. Yes, it's teamwork, but I never forget the fact that it's my name and my name alone that signs that order and everything that goes into it. So, of course, you have to delegate and have wonderful law clerks, which I do now and hope to have if I'm humbled to be on this great court. But it's something that I never forget. Also, what I always remember with every case that comes before me, and it is no different with the appellate courts, is that there are people behind every case. And no matter what kind of case it is, whether it's a complex commercial litigation case or a custody case, it affects people's lives. And I don't think there's any better way to deal with your caseload than to remember that.
Thank you. Well, I've had the benefit for 7 months now of experiencing the overwhelming caseload of the Pennsylvania Superior Court. One of the things I did before I started is I talked to as many of my future colleagues as possible about how they arrange their work. And I got a lot of good ideas. There is no magic bullet for dealing with the caseload. It is, as others have said, it's largely a matter of hard work, teamwork, being smart, being a quick study. We have a high volume of cases. They range from the very simple to the very complex. And I think setting a priority for those cases, recognizing early on as you look at a case, whether it's the sort of case that's going to require a lot of time and attention or one where you can delegate a fair amount of the work to the law clerk is an important part. As Judge McLaughlin said, though, all of these cases are critically important to the people before us. So everyone deserves careful and close attention. But what you have to do is you have to be a generalist, you have to be a quick study, and you have to be willing to work long hours. One of the nice things about the job is that it's a lot of reading and a lot of writing. Those are things that I love to do. It's also things you can do on the campaign trail while you're, as long as somebody else is driving as well. So I think it comes down to hard work, being smart, and a quick study. That's the key. There's no magic way to deal with it.
Yeah, as a judge in the criminal court in Philadelphia, I have hundreds and hundreds of cases per month, conducting jury trials, waiver trials, pleas, motions. So you have to learn how to kind of coordinate and move things together, always recognizing, at least at the trial court level, you're dealing with people that are in custody, they've been in custody for a while. You have to realize that every case represents not just an individual defendant, but a family, a community behind that. There's a job that a person can't get to, or they might lose everything. So you need to understand that the decisions that we make as judges are real. They're real consequences, and they affect real people. So that you always have to have that in your mind and not get caught up in the paper. I understand Superior Court gets approximately 8,000 appeals per year. So that certainly is a heavy caseload, but certainly it's something that I welcome, because a lot of what I'm doing now, respecting the rule of law, respecting diverse communities, respecting the people behind the cases, and making and ensuring that I move expeditiously. Because even though I have clerks, the buck stops here. It's my responsibility, no one else's but mine. So I have to be willing to work harder than anyone else. And that's the kind of work ethic and integrity that I will bring to the Superior Court.
Well, I've had the benefit in sitting in Philadelphia County of being in a lot of high-volume rooms, lots of high-volume rooms, whether it's in family, whether it's in criminal, even in the custody unit as well. And being a general practitioner, I've had a vast amount of experience. But I can tell you what's important in writing so many opinions. Of course, prioritizing, and of course, teamwork, and having a very strong work ethic. And that's what I have. I'm never afraid of a case. I'm never afraid of the volume of work. It's just a system that, as you look at it, you put in place your own personal system that helps you to be more effective and more efficient. And because I've learned to be effective and efficient, every courtroom I've sat in, I've always cleared the backlog, and I had no backlog. I would do the same with the Superior Court with the help, of course, of a great team.
So as district attorney, we're sort of the emergency room of the legal practice, and we are used to high volume, fast pace, and we have to get it right. You only get it, the consequences are so important. We have to get it right the first time and do it for the right reason. What I tell my new assistants is I demand a few things from them. Never get outworked, because you can control that. Never compromise your ethics, and always treat everybody as if they're a member of your family, because they're somebody's family member. And I think, we've heard that from some of the people in the panel about how important it is to see the impact of the justice system on the individuals that are in the system, and it's greater than all of us. And that's important to me. I think the Army also training, we're interested in solutions, not blame. You look for the situation, you analyze it, and you come up with the best solution. I mean, I wouldn't say exactly what I'd do if I got on the court, other than first thing I'd do is talk to all the judges that are on there, talk to the president judge, and see what's the best way of doing it, because there's a lot of wisdom on there. But you have to lead by example, and I think I've a demonstrated record for that. Working together, all parts of the system, we were able to take our caseload from cases over a year or more from 28% down to 6%, and that's because for collaboration. And you have to have the ability to delegate and work together for a common goal. Thank you very much.
Thank you. All right, so we have a second question, and we'll start off with Judge Giordano. In the areas of both civil and criminal law, what do you believe are the most significant appellate decisions from either the Pennsylvania Superior Court or the Pennsylvania Supreme Court in the last 5 or 6 years?
Ones that they didn't overturn my decisions. There have been numerous decisions that come out of the Superior Court and the Supreme Court, as well as the Commonwealth Court. And I'm hard pressed to sit here and give you the name of one that I would say is more relevant or more prevalent or outstanding than another. There was a recent decision coming out of Lehigh County involving firemen, and I thought the decision by the Commonwealth Court, authored by Judge Brobson, which talked about mandatory subjects of bargaining, is one that comes to mind. Other than that's about all I have for you today, Ms.
Well, look, I mean, it's been mentioned here earlier, every decision is important to the people that come before the court. We've been asked, I think all of us will agree that a lot of the organizations have asked, what is some of the most important decisions that you render? Well, they're all important. So I think that every case deserves its level of importance because of the litigants. From a legal standpoint, as a judge who handles a little bit of everything in the Court of Common Pleas, I can think of decisions from the Superior Court and the Supreme Court on criminal law with mandatory minimum sentences. I know just last year the Supreme Court issued a decision on the standing of grandparents, which has affected my docket in custody cases. I know the Supreme Court just not that long ago made a decision on the question of arbitration clauses as they apply to wrongful discharge or wrongful death and survival actions. These decisions all had impact in their particular areas of the law and affect the court's docket and work on a daily basis. But I think that every case, even a custody case, for example, might be a routine case that the Superior Court hears, but that custody case is real important to the litigants before it. So every case has its level of importance. Thank you.
I would echo Wade's concern about the case involving the grandparents standing for custody, where the Supreme Court held that a portion of the grandparent statute was unconstitutional, that portion that allowed grandparents to petition the court when the parents were separate and apart for more than 6 months. That's really going to change the face of how custody litigation goes forward in a lot of the broken homes that we see. Additionally, I believe the case involving the Filial Act, I hope I'm saying that right, F-I-L-I-I-A-L, where it said that children are responsible for taking care of their parents and that the bill for nursing homes can be passed on to my entire generation. I know it's tough for me. I'm already raising my kids and trying to put them through college, and to know now that I might be responsible to pay for a nursing home bill for my parents, I think is a little bit surprising and somewhat overwhelming for people, like I said, of my generation. I think that's a really important decision. Also, the criminal realm, the Richter case that would allow cases to proceed based solely on hearsay at the preliminary hearing level, I think that's going to change the face of the law in the Commonwealth. So those are some that I can think of. And then a final one on the civil side would be the Tincher decision, which changed the face of products liability here in Pennsylvania.
So I am one of just 3 judges in the Court of Common Pleas in Philadelphia that preside over not only family law but also some criminal cases. So with the criminal cases, it is the mandatory minimum case law that's affected at least my decisions the most. With respect to the civil family end of it, I think the custody factors. The case came out that now we have to go on the record and deal with all of the custody factors individually. It certainly has impacted me in Philadelphia with the caseload that we have. Those factors have to be considered on the record or in your court order. Now, many of my orders look like opinions, just on the average custody case, because it's required to by the Superior Court. So I think that certainly has changed, in particular, my practice in Philadelphia.
Thanks. I think people have already mentioned several cases of real significance. I'll mention a couple that I think have the biggest impact on the work of the Superior Court right now. One, as Judge Kunselman mentioned, is the Tincher versus Omega Flex case. That's a case that involved, what evidence is admissible in strict product liability cases. We are sort of every day, I think our court is deciding another case that relates to the questions left unanswered by Tincher. And I think the Supreme Court will have that again at some point, but that's certainly affecting us every day. Also, the mandatory minimum case, Commonwealth versus Hopkins, which applied a lien to several different mandatory minimum cases, statutes in Pennsylvania. That's another case that's sort of, at least I'd say every week, running into a case that has to do with the impact of the Hopkins case and a lien on other cases. So those are two cases that really affect our practice, our work every day. A couple other cases, I guess, that I've mentioned at the Supreme Court level that are significant. The Robinson Township cases, the set of cases over the last 3 years that they've decided, which really have to do more with the Commonwealth Court's business than ours, but they probably are ushering in a new era of environmental rights litigation in the Commonwealth. That's a significant case. I mentioned also the Curran versus Luzerne County case, in which local public defenders are challenged, were given standing to challenge the funding of defenders' offices in the Commonwealth. That's going to have an impact, I think, going forward as well. Last thing I guess I'll mention is In re Bruno, an interesting case in which the Pennsylvania Supreme Court asserted its authority concurrent with the Court of Judicial Discipline to deal with discipline cases. I think that has some interesting impacts, and in fact, I think discussed in the recent report by Pennsylvania for Modern Courts about recommendations to change our disciplinary system in Pennsylvania.
For me as a criminal court judge, obviously the mandatory minimums has had the most impact, but also there have been several cases involving the Fourth Amendment exclusionary rule applying to parole violation cases, so that's a different standard. We get a lot of parole and probation violation cases, so that's a different standard. Fourth Amendment protections in the Birchfield case, which now applies, so involuntary blood draws in DUI cases, our intrusions, warrantless blood draws, so that it certainly is very relevant in DUI cases. That involves different standards. Also, just of personal interest to me, the SRC case, the Philadelphia SRC case, in which I think the Pennsylvania Supreme Court determined that the Philadelphia SRC board violated the Constitution by the application of the distress law in terms of they were able to disavow the school code and cancel out collective bargaining agreements and things like that. And the Supreme Court said that was constitutionally violative. So that was something that I followed just for my own personal interest, as well as charter school rulings as well, which kind of flows through Commonwealth Court and then goes up to the Supreme Court. But certainly the mandatory minimums, the blood draw cases, the Fourth Amendment cases, and the changing standards of when and where the exclusionary rule applies have had the most impact on my court.
I think where I sit currently in the Civil Trial Division, Tincher has had a great impact with the civil cases. Obviously, it's still with products liability. And so Tincher, I would say, is one of those key cases. Another case would be the Robinson Township cases, wherein the court had taken away from the PUC the authority to hear land use cases, which is really big with shale and gas and so forth. I think some other cases relate to when the Supreme Court struck down the juvenile sex offender registration. And also, we're also dealing with in Philadelphia the aftermath of the juvenile lifer cases. So those are some of the main cases that I think have had a great impact on the Commonwealth, especially I've seen in the Philadelphia court system.
Thanks, Paul. I don't think there's any question that the Commonwealth versus Wolf and Hopkins cases dealing with the mandatory minimums have had the greatest impact on our state. Let me tell you what the impact is. The impact is child rapists used to get 10 years in jail. That's what we could go with. Now they're getting about half that, 5-6 years. So they're going to get out earlier than they otherwise would, which means more than likely some child that we don't know down the future is going to get abused as a result of that. Nobody intended that, but that's the real world impact of that decision. What it also does to me as a prosecutor is we have to have those difficult conversations with those victims. We used to be able to maybe negotiate a little bit from a stronger position. Now the incentive for the defendants to negotiate those cases is gone. So children are put through trial. Then they're re-victimized a second time because they have to do that. And that's the way the process is, and we follow it, we respect it, but that's the impact. That's the in the trenches impact of that decision. Birchfeld was mentioned. The DUI, we've had to get rid of a lot of DUI cases, negotiate them. That was a U.S. Supreme Court case, but it's obviously trickled down to us. I think the big decision really coming up that I see, and I know that's not part of the question, but I'm going last, so I have to come up with something new, is BATS, and that's the juveniles, lifers without parole, and involving due process. What rights do they get? And it's such a huge impact. There's so much at stake for those individuals, and it's also so much at stake for the family members of the victims that thought there was a final judgment, and now we have to have those difficult conversations. So that's the biggest one I see coming up.
And Bill?
Yes, thank you. Well, recently I had a stint as of counsel to an LGTB law firm right outside of Pittsburgh, and I would suppose that Whitewood versus Wolf would be a monumental decision in Pennsylvania in terms of equality. And one of the things, again, that's near and dear to my heart is protecting families, and families today take all shapes and sizes. I would echo my colleagues as former prosecutors that the decisions in the areas of criminal law regarding sentencing and mandatory minimums weigh heavily. I think that also the search and seizure laws in terms of the balance, the credibility factors in terms of preliminary hearings, very much handcuff defense lawyers, now that I am a defense lawyer. And I don't think that as a sitting judge, having clerked for several of them at the federal, state, and county levels, that they're going to want to have a record that is of entirety of hearsay. You really can't get to the nitty-gritty in terms of assessing the strengths and weaknesses of your case. Next, I think in the area of environmental law, which again is something that I had familiarity with in the Office of Attorney General, the Robinson Township cases. I think it sheds light on the inequities in the system depending upon rural versus rural. The decision-making of the courts has to be very attentive to the needs of all sides of disputes. And finally, I think the Curran versus Luzerne County case, again, because it impacts justice. And we know that people that have money have a different brand of justice, or at least that's the perception of it. I think that needs to stop.
Thank you. All right. You're up next, Your Honor. What is your experience practicing before appellate courts that makes you qualified to be an appellate judge? And has that experience caused you to develop a philosophy of what the Superior Court should and should not do?
Well, that's a big question for 90 seconds, so here's my answer.
Well, everybody's got the same thing to say.
I was as I mentioned earlier, I was a prosecutor for 15 and a half years, and the second half of that was the equivalent as a first assistant. So I practiced regularly before the Superior Court. Just about every major criminal case you do, if there's a conviction, winds up in the Superior Court. So I had a lot of practice before the Superior Court. I was also had my own law office where I did litigation, so that caused me to practice before the Superior Court on occasion as well in family law cases and to a lesser degree, of course, civil cases. So I think that experience obviously is a benefit to being a Superior Court judge. Having that appellate experience as a lawyer is a benefit to seeing how appeals work and how appeals are litigated. And I think that it also, as a lawyer, gives you an understanding of the impact of the workload the Superior Court is doing and the need for judges to be efficient and effective in their operations and on the work that they do. So I think it's having that broad-based experience both as a trial lawyer and an appellate lawyer is a benefit.
Judge?
I did also practice in front of the appellate courts as a lawyer. In addition to my private practice, I was also the county solicitor in Beaver County for 8 years. And so we had several issues that had gone up to the Commonwealth Court. So I've appeared before the Commonwealth Court many times, and then the Superior Court, again, in family law and in civil cases. I think it is important that a judge on the Superior Court has some familiarity with how it works from the other side of things, so that we can appreciate the role of the lawyers that are coming before us. Appreciate the fact that they've had to put 7 copies together in 14-point font and meet the page requirements and the margin requirements and things of that nature. And so one thing about the second part of your question was about the philosophy of the
you
court?
developed a philosophy because of your experience before the appellate court.
Sure. So I think that it's important that the Superior Court doesn't try to Monday morning quarterback or substitute their judgment, because that's not what their role is. Again, we're an error-correcting court, so we want to make sure that the trial court did or didn't make a mistake. But one of the unique things that the Superior Court will get to do is interpret statutes. And sometimes when I get that even as a trial court judge, I will say to the litigants, well, I'm going to make my decision, but I know somebody upstairs is going to be looking over this. And so that you get the opportunity for 3 judges to collaborate and to give their perspective on statutory interpretation, especially when it's a case of first impression. That's one of the things that I'm most looking forward to doing, is being able to look at a statute and decide what it should say and mean for the folks in Pennsylvania. Thank you.
Judge.
So I think as a judge of the Superior Court, I think beyond having to be recommended, I think it should be absolutely required that you have appellate experience. I mean, it's certainly something that should be of utmost importance. If you're wishing to preside on the other side of that bench, you should have had experience in that area. Again, starting off, my young legal career was as a clerk for the President Judge of the Superior Court. So I certainly had an experience with a plethora of issues that came before that court, and I know what it takes and what you have to do when you are a Superior Court judge. Additionally, then being a district attorney, I've argued countless times before the Superior Court in a number of different issues. And I've had a number of really great decisions, even on that level. But then bringing it back to what our philosophy is and what I do as a judge on the bench in the Court of Common Pleas now, it is an error-correcting court. I can't be more proud of the fact that despite the fact that I was elected in 2011 and sit in courts where they are the most appealed cases to the Superior Court, that I've only been appealed 5 times and have never been overturned, I take that and I take it with pride, because I think what better experience can you bring to the court that you're wishing to aspire to than that background?
I agree that appellate experience is an important qualification for an appellate court judge, as is trial experience, frankly. You're not going to find many candidates who have experience in all of the things that the Superior Court confronts. One of my first argument sessions in the fall was a pure adverse possession case, and I had not thought about adverse possession, I think, since the second semester of my first year in law school. So you're not going to have substantive experience in everything that we do, but having experience with both the appellate process and the trial process is an important qualification. I started out with 2 appellate clerk clerkships at the federal level in the Second Circuit for Judge Feinberg and for Justice Rehnquist on the Supreme Court. So I started out with a good appellate perspective. I was an assistant U.S. attorney for 8 years where we handled our own appeals. Didn't have a separate appeals unit, so I had a lot of experience in the Third Circuit. My most recent experience as an advocate was in 2015 defending the governor's constitutional authority to issue reprieves in capital cases before the Pennsylvania Supreme Court. I was successful there, so I'm 1 for 1 as an advocate for the Pennsylvania Supreme Court. Now my decisions are being reviewed in a different way, so I'm not sure I'll be able to keep that record intact. But in terms of approach to judging, I mean, we are an error-correcting court. Our job is to do justice. We need to get the right result for the right reasons clearly articulated, so that in cases of narrow importance, but to the litigants, they understand what we did, and in cases of broad importance, the bar and trial court judges understand what we did. So I think being an advocate is crucial. Obviously, we know appellate lawyers have a crucial role in making sure that we get the right result for the right reasons, and again, clearly articulated.
Well, as a young lawyer, I was an assistant city solicitor, and I did have the opportunity to do appellate work before a Commonwealth Court involved with employment cases as well as before the Third Circuit. I litigated Title VII cases at the trial level in federal court as well as arguing cases, so I do have that experience. As a trial judge now, I've written over 60 opinions to the Superior Court, and I've learned one thing: the record is your friend. So I've learned as a trial court judge, you want to make sure that you understand the record and how the record works, because when the case goes up to Superior Court, that's what the Superior Court is looking at, primarily the record, because other documentary evidence may or may not get up there, we're finding out. So the record will show the entire history of what happened in that case, what the judge's rulings were, and so that the Superior Court can determine, depending on what the errors are that are complained of, whether there was a legal error, because it is an error correcting court. But it's all about justice. Superior Court's about justice, to make sure the overarching concern is not to just look for errors, but it's about justice. Was justice served at the trial level? Did the defendant receive a fair trial? And my philosophy to close out is procedural justice, to make sure that there's fairness and balance and justice in what I do at the trial level, and then the Superior Court level will take care of itself.
My experience has been when I was a civil litigator, I did practice before the Commonwealth Court as well as the Superior Court. I also had cases in the Third Circuit as well. So I do have that level of experience as an attorney. Also, as a trial judge, on my 14th year on the bench, I've had plenty of experience in writing opinions and, of course, reviewing records and sending the records up and so forth. But I think the philosophy of a Superior Court judge should be follow the law. You know, it's important that the law is followed, and that a judge on the appellate court should never substitute their opinion for that of the trial court. The law and the facts are clear on the record. Unlike a trial judge, the appellate court has the benefit of looking at the entire record. And so the law should be something that the court should be interested in following, and I do believe that, because I also believe that justice should be done, obviously not on just the trial court level, but of course if it's appealed, it should be done at the appellate court level too. I think that all citizens deserve equal access to justice.
Thank you. So I started out sort of 50-50 appellate law and trial law for a number of years. So I got experience both. Honestly, my appellate practice made me a much better trial lawyer, made me much better prepared to present the homicide cases and those important cases in front of our juries. But being a judge is about making decisions. And some days I kind of, as DA, feel like nobody has to make more decisions in any single day than I do, constantly coming across me, whether to charge, if to charge, with what to charge, should we appeal, should we not appeal, if we're appealing, what should we focus on? Everybody comes to me for the answers, and I wish I had a panel on some days to help me out, but it's me, and I've done it under public scrutiny. I'm responsible for, talk about your name, I'm responsible for what comes out of my office, for every assistant, for everything they do, and I take that very, very seriously. I think it's important as well that you understand, and people have mentioned it too, but the impact, of people in the justice system. It's not just appellate experience, trial experience. I think it's all great. You have to be a good lawyer. That's what you have to be to understand it, because particularly from the prosecution aspect, we need to make sure the conviction stands. We're not doing the victim's family any favors by getting a conviction and just knowing that it's going to get overturned. You have to follow the law, but you have to also appreciate the effect on people, and you need experiences in life beyond just appellate court, beyond just trial court experience to really make a good appellate judge or judge in any fashion as well. And my philosophy is pretty simple: follow the facts, follow the law, do the right thing for the right reason, and got the stop sign timed to perfect.
Yes, sir. My philosophy is, in everything that I do, is to put yourself in other people's shoes, to try to think the way that they would think, to give 100% commitment and dedication, but most importantly, to remember where you came from and treat others as you would like to be treated. Having clerked for several different judges, you adapt to the managerial style, having written and researched intensely emotions practices in civil and criminal, having that balanced side of things, and not to be afraid to say, hey, look, just because this is the way it's always been done doesn't make it right. I think keeping it simple, that's what I do when I teach and I lecture younger lawyers. Say, hey, look, pick one or two of those arguments and hone in on them and use the facts. If you don't have the facts, then use the law. I think as an appellate court judge, your role is a little bit more restricted and limited, but you still have to be respectful of the process and mindful it is a process. And you should be there to listen to people. You have 2 ears for a reason. And I worked for judges that did not take an activist approach to trying to be the lawyers that appeared before them. It's a very refined role where you have to step back and say, these lawyers have a case and their clients deserve a fair hearing. So that's my philosophy. That's how I would judge. And my experience has always been to be a team player, to prepare those briefs, to make those arguments, whether it was in the civil court or the criminal court, but to be true to the facts. You know, a lot of times people are trying to pull fast ones, and I think that a lot of judges get upset. I think if you were a judge, it would be disrespectful not to be full and fair in your presentation of the record. And that's how I would judge.
You know, I have to say going last is a lot easier than going first. I have to disagree with some of the other panelists. I don't think that being a advocate before the Superior Court or the Commonwealth Court is going to be that helpful to be sitting on the Superior Court. I appeared before the Commonwealth Court and Superior Court numerous times as a lawyer, but I was an advocate in those positions. As a sitting judge for 14 years, and I think Judge Patrick has it right, you're looking at statutes and you're looking at the plain meaning of words and you're trying to apply them to the cases before you. While it's important that justice is done, as an appellate court judge, your role is solely, in my humble opinion, was the law followed, not was a certain result reached. And it's important that you not substitute your judgment for that of a jury, and you not substitute your judgment for that of a trial judge just because you would come up with a different decision. I think a cool, calculated review of the law is imperative, and it has to be, has the law been followed? It cannot be result-based. That's my opinion.
Okay. All right, so now we're going to have the question is for our partners here today, for the Pennsylvanians for Modern Court. We're going to get into some, a little more important issue, but maybe a little bit trickier. Campaign contributions are permitted in Pennsylvania. The public is certainly cynical and confused about this practice. Is there any dollar limit or time limit that should be imposed to trigger a recusal? And if there's not a formal rule from the court, do you have a personal policy that you would adopt if elected? And lastly, would we avoid this problem if we appointed judges? Have I covered it all? Judge, Councilman, you're up first.
Wait, did you answer the last question?
Yes.
You did the last question.
Just checking. Okay. Well, in terms of campaign contributions for judicial campaigns, I'm finding that there's a very limited audience to even want to contribute to judicial races. And mostly that's the folks that are sitting in this room, all the lawyers, right? Because they want to see good judges get elected. Would I set a dollar figure? No, I don't think so. Would I recuse in a particular case? I think it would just depend on the subject matter that came before me and whether I, in fact, even knew that somebody had made a substantial contribution to my campaign. I think the lawyers get it, that they know that this is part of the process, that we are, in order to get our name out, that takes money. And so we have fundraisers, or there's fundraisers held on our behalf, and campaign contributions are made to our committees. And the Supreme Court just held 2 years ago that it's still inappropriate for judges and judicial candidates to solicit money on their own. There was a challenge to that in 2015. The U.S. Supreme Court said, no, judges, you can't do it. There's just something distasteful about a judge being the one to make the ask for the money. So when I would recuse would be what's required under the canons of judicial conduct. I believe it's Rule 2.11. Whether somebody thought that, whether there would be the appearance of impropriety, if there were in fact a large campaign contribution to my case or to my campaign, then I would recuse, or any of the other elements that are listed in that rule. Thank you.
So it's not much different than running for the Court of Common Pleas, except for the amount of money that you have to raise. But I think that's the benefit also of having been a judge and being a judge now, that I have a proven record. So I think anybody that knows me knows I'm beyond reproach. I've never called out sick one day since I was elected. I left the district attorney's office with 170 sick days, despite the fact that I went out on maternity leave twice in a row. I mean, these cases that come before me now, they're decisions that you have to make. It's the appearance of impropriety. It's not just whether or not you believe, it's whether or not what the appearance is. So I think having a proven record certainly makes people more comfortable to give to me because they know that they're not giving for any reason or going to get anything back because they never did. I'm a sitting judge now. Nothing would change if I went to the Superior Court. With respect to whether or not it would be better off if, I think it was, we were not elected or we were merit selection, there's a number of issues, and you certainly can't answer that in 90 seconds, but there's a number of issues both ways. What I can tell you is the benefits that I'm seeing in having to be elected. I am seeing people throughout the Commonwealth engaged. I am seeing voters caring about the appellate courts, unlike I've ever witnessed before in my over 25 years of legal experience. So I do see things changed. But with respect to me personally, I don't think that it's any different than when I ran for the Court of Common Pleas.
Well, in Pennsylvania, we elect our judges for better or worse, and we'll see if I have enough time to answer the last part of the question. But one of the consequences of that, obviously, is judicial candidates, in order to be successful, have to raise money. And inevitably, they're going to raise money from lawyers and, in some cases, litigants who are going to appear before them. And that creates, I think, a legitimate concern on the part of the public about whether or not judges are going to be fair in those cases. And how do you deal with that? You deal with that either through recusal, and I've recused myself, I'm living this right now on the Superior Court, recused myself in a number of cases so far in my time, 7 months on the court, or you deal with it through notice to the parties. And so what I've done in a number of cases is had the Prothonotari's office send a letter to the lawyers explaining that one of the parties in the case or one of the lawyers in the case has contributed X amount of money to my campaign. That is out of a total of X that I've raised, of Y that I've raised. Please feel free to file a motion to recuse if you believe that you want to. I believe I can be fair and impartial, but I'm interested in your views. There are many benefits and shortcomings in terms of the various ways of electing judges. Until 1850, we appointed judges in Pennsylvania, and the Constitution was amended because there was so much corruption in the appointment process. So it's not easy to say that either merit selection or elections are better. There are a lot of benefits to the electoral process, as Judge McLaughlin said. We get to meet with and talk to a lot of people around the state. We have forums like this, which we wouldn't have, frankly, if there was an appointment process. On the other hand, the role of money and fundraising in electing judges is a serious concern and a real reason to look closely at proposals for merit selection.
Judges and money, it can be problematic. I know there have been attempts over the years, Judge Moulton talked about since 1850, but since 1968, there were also more serious efforts to try to bring the appointive process back, which was the original process before 1850. And I know there was legislation that kind of was tabled in 2015, which took a hybrid approach, sort of taking the best of both worlds, taking the appointive process and kind of combining it with having at least a retention. So the idea of having a hybrid process where you have a bipartisan citizens nominating panel, with diverse citizens, lawyers, non-lawyers, community people, selecting, evaluating candidates, submitting those names to the governor. The governor selects nominees, presents them to the Senate approves them by 2/3 majority, and then there has to be a retention, up or down, nonpartisan, every 4 years. Has its appeal. But of course, to get that process going requires a complex constitutional amendment, which I think is through 2 legislative sessions, has to be approved, and then there has to be a referendum. So there are a lot of steps which have not been successful as of yet. As a judge, you just have to be, if you follow the rules of judicial conduct, you can't go wrong. You disclose if you do have attorneys that appear in front of you. I think the language talks about significant amounts, whatever that feels like. If you conduct yourself according to the rules of judicial conduct, you can't go wrong. And stay tuned for the resurrection of the appellate process, of the appointive process.
Well, I think that judges should certainly be elected. I'll answer the last part first. And I'll say because someone like me, African American, female, I didn't come from a large law firm, I may not have had a chance. And if you look at the jurisdictions where judges are appointed, there is a lack of diversity in a lot of those situations. I think someone said that if you're not at the table, then you're probably on the menu. So I can say, running for the office, at least you get a chance to be at the table. And it's up to the voters to select who they would like to select. Now, when it comes to raising money, I mean, let's be honest here. It takes money to run for judge, and a lot of it. And I think that anyone up here would be remiss to not acknowledge that. And you have to reach out to family, friends, and other people. Now, as a judge, you have an obligation under the canons. Can you be impartial if someone appears before you? And the other question is there the appearance of impropriety? You have to answer those questions legitimately. And depending on what your answer is, you should recuse or you should not recuse. But I think it's very personal to the judge. But I can say that anyone given to my campaign, you don't get anything for it, except for just being a great judge on the bench. But that's it. But I do think that we should continue the trend of electing judges rather than appoint them, because there's going to be a group of people that probably will be overlooked. And I believe in being at the table.
Well, obviously, it's a great concern. There's advantages and disadvantages to the different viewpoints. This is the way it is, and we have to deal with the way it is. I know Representative Cutler from Lancaster County has an interesting proposal, one that tries to sort of mix some of the balances of things, but we're running, and we have to collect money, and it's uncomfortable for me to do. I think probably most of the people to do that. You can't do it directly. You have to follow the canons, but that's the easy part of the answer, is you have the canons to go fall back on. You have the rules to fall back on. And ultimately, really what it comes down to is, do you have the inner moral compass to follow it? And I've been in situations for many years, really, for my career, where people have made a phone call or maybe to an ADA or to myself and said, hey, I know this person, can you do them a favor or something like that? And I have a proven record of just treating everybody equally. And if there is any suggestion or thing that I should have conflicted it out, it's easy for me to do. I conflict out the attorney generals, and I do that on a routine basis when there's an actual conflict or there's the reasonable appearance of it. So this is a really complicated question, but I think there's a short answer to it, and we have guidelines to follow, and we can always look them up, and I think that provides a great foundation.
Yes, I think being part of both an appointed process and an elected process, just recently in my own personal life, I had the opportunity with Governor Wolf to sit for an interim judicial appointment process, and it fell a little bit short, but I was grateful of the opportunity. And I had run for Common Pleas Court in Allegheny County, and we had a committee assembled to do the asks. There's good and bad in both of those processes. I think endorsements from special interest groups, nonprofits, labor organizations, I think all of those bring out sort of a bad taste in the public, especially individuals that are working for the taxpayer and campaigning for other offices. I think, again, that creates a perception of entitlement. And my campaign is based on the people. I'm not going to discriminate against the people, and I'm not going to do something that puts the bench in disrespect, because, again, we have to be respectful of the office, which is the judiciary. And the judiciary has to be independent, and dark money should not enter into politics when we're electing our judges in Pennsylvania.
I think all the other panelists have brought up all very valid points, and I tend to agree with most of them. I think the issue of litigants giving you money, and I'm pretty sure the rule says a judge shall recuse himself in those situations when there's an appearance of impropriety. I've actually written a decision on this issue where I was involved in a case where both of the lawyers had contributed to my campaign as well as one of the litigants, and they all wanted to waive the conflict and still had me hear the case. And I found myself in Hobson's choice, and I determined that it was not appropriate for me to hear a case where one of the parties had actually contributed to my campaign. I think, and being a judge like most of us are here, we've had lawyers appear before us in our counties who have contributed to our campaign, and I've never had the question raised, can I be fair? These are public records. They're readily available. If there's an issue in your mind, I think what I've done in the past, I've taken people in the chambers and said to both lawyers, he's contributed, he was on my campaign committee. Do you want me to recuse myself without the formal need for a motion? And we've handled it in that fashion. I think appointments and elections have too serious, 15 seconds to go. There are good and bad to both sides. I personally believe that an appointment process with an election after several years in office, where it can, rather a retention or confirmance after several years in office, would be the way to go.
Thank you. The rules of conduct speak to this issue. You have to weigh the amount of the contribution with the overall amount spent on the particular campaign. That's obviously going to affect Court of Common Pleas judges a little bit different than appellate judges, depending on the amount of money that they raised, the amount of money, the contribution. There's kind of an implicit in that rule, a balancing test there. So I think that would be my guide, is to follow the rules. But I also think at the end of the day, too, it's about integrity. It's about transparency and disclosure. I think it's important for a judge to disclose when there's any question of impropriety. I do that on a regular basis as a trial court. If I might know somebody, if there's a contribution, whatever the reason, I try to disclose. I think that's important. To me, my integrity is really important. I tell people that I put my hand on the Bible a couple times in my life. Once was to become an infantryman, once was to become a prosecutor, and the other was to become a judge. And that oath is more important to me than any support or contribution that I've received in my campaign. As for whether or not it would be a better process, I do favor the election of judges, but I do also understand the concerns that are raised. They're legitimate concerns. I think it's worthy of a public debate about that. I served on a merit selection panel in the Western District in the selection of federal judges as an appointed member, so I understand that process. And I think we just need to take a hard look at all the options. And there are also regional elections, other things that have been put out there as compromises as well that I think need to be looked at.
We have everybody then?
Yep.
All right, Judge McLaughlin. Explain what you have done throughout your career to support diversity and what you would do to support diversity going forward.
Well, I have a diverse staff, that's first and foremost. And secondly, what I do, and what many people in the Philadelphia system at least know, is every Friday I open my court up and I mentor young people, mostly inner city people. Whether they're law students, they can even be college students. Doesn't matter to me. All of the local law schools call me every Friday afternoon. That's what I do. I have that kind of a list where I can sort of be a professor and a judge, where they get to see a number of issues because they're quick cases on Fridays and they're all morning cases. So I have the time to take with each of these students. And I take great pride in that. Also, what I do is out in the community. I chair a youth anti-violence campaign where we go out to 7th and 8th grade students, mostly in the minority communities, and have them write essays, write, W-R-I-T-E. And it's not who has the best written essay, it's who has the best message. So it's extremely important to me, both as a judge but also as a person. It's what I've done throughout my entire career, not just now that I am campaigning for the Superior Court. Everything that I've done my entire life. I've done my entire legal career. So it's extremely important to me. And I've proven that based on my record and my life history.
We are a statewide court with responsibility for cases involving people from all walks of life and from all over the state. So it's really important that our court reflect diversity. The more diverse our perspective, the better job we can do doing justice. In my career, I've had the opportunity in over the last 10 or 15 years to be responsible for hiring in a number of different places. And I have in each of those instances promoted diversity in the hiring process. Most recently, I had the chance to work for Governor Wolf, really for Denise Smiler, who's the first African-American general counsel in the Commonwealth. And one of the things that General Smiler and I did right at the beginning is we noticed that we had 32 chief counsel throughout the state and not a single African-American. We worked very hard in terms of outreach and in terms of looking for diverse candidates. In the course of a year and a half, we had 4 African-American chief counsel from 0. And it's not easy to attract folks to come to Harrisburg sometimes. So we worked hard and did a great job doing that, I think. And I did that when I was at the U.S. Attorney's Office, when I was first assistant, also in charge of the hiring committee there, worked very hard to bring a greater level of diversity. So I think it's really important. Interesting, to Judge Patrick's point earlier, I think my experience or my perspective is one of the downsides of electing judges is historically I think we haven't done as well in diversity as we have in appointment process. Happily this time, I think in this year, both slates in terms of geographic diversity and other diversity have done very well. So we actually happily have a broad and diverse group of folks running this year, but that's not always the case in elections.
Well, as an African-American woman judge, I consider myself a living example of living, breathing diversity. And I also utilize my courtroom because I believe a courtroom is not just a place to litigate cases, it's a place to transform lives. So I bring in kids from Overbrook High grad. If I have any Overbrook High in the house, grads in the house, now's the time to holler. But I bring in kids from high schools to come into the court to understand that, you don't want to make a mark on your life that you can't erase. A felony is not some kind of rite of passage. It's not cool. This isn't some kind of, music video. This is your life. So we bring kids in. I go out into the community because I still live in my same community where I grew up, to go to schools to show people that, look, I'm nothing special. You can do what I just did. I go back to my high school and say, look, you can be a judge, you can be a doctor, you can be whatever you want to be. But don't let anybody cheat you out of your opportunity, because what I find in creating diversity, creating opportunities, it starts with the person. If the person doesn't have the self-esteem, doesn't think themselves worthy of achieving anything, you can talk all you want. They're not going to achieve. So I tell young women, for example, he's not that into you if he's trying to get you to carry drugs and a gun in your pocketbook. Don't get cheated out of your future for something stupid. You're worth it. Your life matters. And this is the kind of example that I set in my courtroom in my life to help the next generation move forward.
Well, even when I was a lawyer and I had my own practice, I've always been committed to diversity. One of the things I would do is I would hire young African-American females in high school to be my file clerks. Most of them came from single-parent homes, and I would mentor them, and they all graduated from college except for one. I had 7 of them during my tenure as an attorney. As a judge, I have always been adamant about having a very diverse staff. And of course, in my 14 years, I've had all types of people working for me from all backgrounds, and we have such an amazing time in the chambers with the diversity. It's great learning from other people and sharing, who you are. I believe that, since I've worked in the court system, I too have had not just high school students, but middle school students come to my courtroom, and a program that I started, A Day with a Judge, where I would have the children to come in, the young people to come in, and they would observe the court and would see me in action from about 9:30 until about noon. I would then take them to the judicial dining room, and I would feed them lunch with my own money that I paid for lunch, and we would sit down and I would engage them in conversation as to what they thought about the process, because a lot of the kids, they always saw the justice system from a negative perspective, and it gave them a different perspective, and just to see them light up in the end at the discussion over lunch was just truly amazing, and it's just a feeling that I just can never forget. Also, I mentor at Strawberry Mansion High School, Women of Tomorrow program, and I do different things like that because you have to remember where you came from and where you're going.
The most recent thing for me was I had to sit down with the individual's family who had been killed by a police officer shooting, and I was fortunate that I have a strong relationship with our NAACP chapter, and they actually sat in the meeting with me. We've been meeting with them for years. We've had open forums on issues. These are big issues facing our country. For me, I see it, and it was never an issue for me personally. And one of the things that I always think about is the military service. And we all bleed the same color. We're all Americans. We're not white, black, yellow. We're Americans. And you have to remember that. And I can tell you just my experience, the media calls me, they want to know the age of somebody, the gender, the race. I actually tell them most of the time I don't even know because I didn't ask. It's not important to me. It's the person that shot somebody, it's the person that got shot. That stuff comes up later. And I think, we have to be mindful of that as we go forward. For me, you talk about opportunity, talk about diversity, it starts with education. It starts with, of course, your family, but then education. That's why I'm a proud member of Fight Crime, Invest in Kids, which is really put the resources in early on, invest in those kids, preschool, give them the solid education that will give them the foundation and give them the opportunity to succeed in life. And it's worth every bit of it. I've also created the first ever, and for my county, outreach coordinator, not a lawyer, not a detective, simply somebody that came in and her whole job is to simply work with schools, work with organizations, and try to get out there and get a message to prevent crime. The best statistic in crime we're ever going to have is the one that didn't take place because we reached somebody early on. So, thank you.
Yes, as a proponent of equality and equal justice throughout my career, being involved in bar association organizations, working alongside some very strong women, and allowing women to actually take the lead in cases as a second chair, have no qualms about promoting diversity throughout the course of my career. I'd like to substitute that word diversity with one of inclusion, because after all, I think that's really what equality is. It's including people, giving people the opportunities that would not have otherwise had the opportunities, whether you're African American, Latino, whether you're gay, whether you're straight, whether you're Catholic, whether you're Protestant. We have to step up as professionals in a noble pursuit of justice, and that means we have to include people. My father was a coach. He believed in integrating. He believed in playing the best players and playing in the high level of competition. So if we refuse to allow people to sit at the table because of their race, because of their gender, because of their age, or maybe now because they're veterans, maybe we don't agree with them, then we're not promoting diversity. I'm going to be somebody that champions it because I live it every day. I was a product of it, and I'm proud of it. Thank you.
As the firstborn son of Italian immigrants, and the first of my family to go to high school, actually, I'm in favor and have always supported diversity, and that's why I was brought up, to look at a person and not at their race, religion, or sex. Also, as a baseball coach and a basketball coach for the last 12 years, as well as a college professor at Moravian and DeSales University, I've always experienced diversity in all aspects of my life. My staff has been extremely diverse. And it's, like Mr. Kay said, one of inclusion at the table in all aspects of my life. And that's where our courts are headed, and that's where they are now.
Yeah, I think it's important to engage in hiring decisions and be inclusive. I did that as a supervising prosecutor. I do that in my chambers. I also think it's important for the court as a whole to have outreach on issues of diversity and inclusion and members of the community. Our court in Blair County does a good job of that. We have good working relationships with the Blair County NAACP and other groups that would promote diversity and inclusion. I've also, for about 8 years, been a adjunct professor at a local community college, and I teach in their criminal justice and sociology department. There's students in there, obviously, that want to go into the criminal justice field. It's a regular part of the classes that I teach on criminal law and the court system about diversity issues in law enforcement and the criminal justice system. So those are all ways to promote diversity and work towards inclusion.
No, I didn't get to go. So on diversity, the first law clerk that I hired was a young lady from Venezuela. She was the most qualified person. That's why she got the job. I've also hired a Jewish law clerk, which in Beaver County, he's the second Jewish lawyer in our county. I know that's not true here in Philadelphia, but it is in Beaver County. So just to let you know, I do think it's important that we look at the qualifications of people and that we give people an opportunity. Like Carolyn said, she's a walking, Judge Nichols, a walking picture of diversity. I'm the first woman, the only woman on my bench, and so I have experienced some of the old boy network, even in my office. I was also the first female county solicitor, so I tried to blaze new trails as a woman in this profession. And I think we also have to recognize the socioeconomic differences of the people who come before us and who work with us, that not everybody has what we have. And just in terms of the inclusion, and when people come to the court system, I think we just have to accept them where they are and not judge them by their background. I recall a case where a gentleman walked into my courtroom in a pair of shorts and a t-shirt, and I thought about saying something to him about his clothing, and I thought the better of myself and caught myself. And at the end of his presentation, he said, "Thank you, Judge, for not commenting on my clothes. I am a disabled Iraqi veteran." And this is really all I had. But he wanted to get custody of his child. And so I think we just have to recognize where people come from, and that, the service that he gave to our country, and just make sure that we are not judging people or the book by its cover.
All right. So this is the good news and the bad news. We're at the end, almost. I have one wrap-up question. That the deal was that the final sign-up question would be 1 minute, not a minute and a half. And if the timing is right, we might go 4 minutes or 5 minutes over, if that. So here's the final question. I think we start with you, Judge Moulton. All of the candidates here are very qualified and experienced. What distinguishes you from the other candidates when it comes to how you will serve on the Superior Court that should warrant us voting for you or supporting you? And please limit it to 1 minute and just 2 reasons. Thank you.
Okay. So I think I'll focus on qualification. I will agree with you. We've seen and heard from a terrific group of candidates here. Really, the Superior Court and the Commonwealth is fortunate to have as many well-qualified candidates as we have here today. I guess I'll focus on my qualifications. I have a very broad base of experience. I've been a federal prosecutor, chief counsel to United States Senator, and counsel to the governor. Again, I'll emphasize the criteria that the Pennsylvania Bar Association emphasized. I also was highly recommended by the bar in terms of professional competence, integrity, and judicial temperament. I think I fit the bill there. If you want to know what kind of judge I will be on the Superior Court, we have 7 months of my work. I've issued well more than 100 opinions during that time, so plenty of reading out there. If you just want to read one, I'll mention a decision we issued yesterday in re Estate of Carter, a case in which we found that same-sex couples have the same right to establish common law marriage in Pennsylvania as do opposite-sex couples. I think that product shows my intellectual ability, quality of my writing, and my judgment as well. Thank you.
I am too honored to be here, among my colleagues with so many varied backgrounds and people with tremendous qualifications that they're bringing to the Superior Court, or would like to bring to Superior Court. What I think I bring is a very diverse background. Well, I'm diverse myself. As I said, I'm a living example of diversity, and my legal background has been very diverse. I've worked in local government, in city council, as assistant city solicitor. I've run my own practice as a civil rights lawyer, and being a criminal court judge for the last 6 years. Really committed to making a difference with following the rule of law, respecting diverse communities, and I want to bring that perspective to the Superior Court, because you have to have a broad base of society. Pennsylvania is very diverse and very varied, and our courts should reflect the population of Pennsylvania. So I'm ready to step up to Superior Court and bring the same diversity, work ethic, and fairness that I'm doing right now in Common Pleas Court.
Well, I come and that I'm different in that I have a very extensive trial record, not just as an attorney, but also as a trial judge. As I said earlier, I am the only judge here that has sat in every major division in the largest court system in the state. I've sat in juvenile, criminal, family, as well as the civil trial division. The other thing about me is that I've written so many opinions that demonstrate my legal expertise that I'm very proud of. I was also highly recommended by the Pennsylvania Bar Association. That's one of the things that they pointed out about me, is that I've had such a broad range of experience that demonstrate my legal expertise. And obviously, I'm an African-American female. So I bring a different perspective to the court, and I'm happy to do that, and I'm excited about the possibility of getting to the Superior Court. But I think that I have been, throughout my career, very, very hardworking, very focused, and interested in rendering justice, and I would do the same on the Superior Court.
Now, don't count this as one of my 2 reasons, but as DA of Lancaster County, nobody else here has had to deal with the Amish Mafia. So, I've had to do that. So, one of the things, I never really thought about running for judge, but one of the things I looked at, and I didn't even know it, was most of the cases of the Superior Court are criminal. You got 15 judges there, not one is an elected DA. And yet the bulk of the cases are there. And I think that there's a place at the table for that kind of a background, looking at, since that's mostly what they do. As I said, I was honored and humbled to get the recommendation, the highest recommendation from the Pennsylvania Bar Association, and what they noted for me was my commitment to fairness. I have a proven record for that, for the defendants' rights, and for fighting for the victims and the police as well. And I've demonstrated it in like I said, the crucible of public scrutiny. I'm running out of time, so I'm running out of things to say. I have like a million things to say. But, I guess I'll just focus on, again, what I said. My core message is doing the right thing for the right reason and making Pennsylvania better.
Yes, the people that know me best in Allegheny County, like the Bar Association Judiciary Committee that twice recommended me to be a judge, know that I do the right thing for the right reason. Again, trust and confidence in the work ethic. I think what distinguishes me from some of the other individuals, I've actually appeared in many of the counties that these appeals arise from. I have a reflection and a flavor for the judges, their decision-making, the populace, the people. The people is what it is all about, folks, and that's why I want to be a judge, to help people. I don't need this job, I want this job, and I'm going to tell you what none of the other candidates will tell you. After 10 years and 1 term, I will gladly pass it on because, again, why? I believe in diversity. Thank you.
I would ask prospective voters to examine the breadth and the depth of my experience. I don't think you're going to find another candidate who was a DA, public defender, private criminal defense lawyer, represented plaintiffs and defendants in personal injury cases, was a municipal solicitor, commercial lawyer, over 100 jury trials, several hundred non-juries, and everything from family court to commercial actions. I was head of the domestic relations section, presently head of the Orphans Court in Northampton County. I sit on a statewide Orphans Court committee, which is establishing new guardianship rules, not only taught at the college level, at the graduate and undergraduate level. I've recently had the opportunity to instruct other judges at our statewide seminar on the new guardianship rules. Thank you very much.
I think a number of reasons, but the breadth of experience is important. As a litigator, I believe that I probably did handle cases with just about every area of the Superior Court, maybe 90 to 95% of those. And being a judge that handles a wide variety of cases on a daily basis is also a benefit. I also agree with what Craig Stedman said. I believe that we have a lot of fine judges on our Superior Court, but there isn't a lot of prosecution experience, people who have lengthy careers and time as a prosecutor, which I have. I don't think there's any veterans on the Superior Court, so I think that those are just some of the reasons that my candidacy would be different than the other candidates and of value to the people of Pennsylvania.
Judge?
Well, one of the things that I think distinguishes me is that I've served for the last 6 years on the Judicial Education Committee, and I consider myself to be both a scholar and a teacher of the law. I want to just keep learning, and I look at every opinion that I write as an opportunity to teach, not just to teach the litigants about what this law means and why the decision is what it is, but also to teach the lawyers what's expected, and I pay very, very strict attention to the standard of review at each and every level of the case. And I'm also highly recommended by the Pennsylvania Bar Association, and one of the things that they commented about me was that I had a writing style that was very clear and easy to follow. And I think that's one of the things you want from an appellate court judge. You want to be able to understand the opinions that are rendered, and that they make sense, and that they're clear and easy to follow. Again, I think it's an opportunity to teach the law in an appellate position.
And I think when you're looking at the candidates overall, you need to look at their backgrounds. And I think I have the perfect background to have me ascend to the Superior Court. Again, starting off with my experience in the Senate, clerking for the President Judge of the Superior Court, being a judge in the largest judicial district, 19 years of prosecutorial experience, Also, from day one, from when I was a lawyer, 25 years, I have been involved in the education of attorneys. Going through as a judge, I co-chair education committees. All of the things that I've done from day one, not just in anticipation of running. But the most, probably the best compliment I ever got from an attorney was that I bring a human element to the bench. That's important not only at the trial level, but also at the appellate level. Again, I never forget that there is a person behind every decision that I make.
Thank you. Well, we're at the end. See Judge Jackson looking at me saying, I never heard you finish on time. My half-hour closing should go on for 2 hours. But just one more thing, Your Honor, just one more. But thank you, everybody. I think maybe, Deborah, you should have the last word of what we have here. And again, I'm honored that I was asked to do this.
I am so impressed that you came in on time. This is amazing. I did not think this feat would be able to happen. I want to thank everybody for coming. I want to thank all the candidates for participating. This was a great event, and it really is important for you to come out, to get people to vote. The elected officials are how we are living in Pennsylvania right now, and it's really important to educate the electorate. So please spread the word, and thank you very much.